Hello and welcome to the Week 5 online podcast for LWS011 Journalism Law. I'm Peter Black. For the past few weeks we've been looking at defamation law. This week we turn our attention to a related area of law, namely privacy law. And we're going to be approaching this topic from a few different dimensions. We're going to be beginning with the probably obvious question, what is privacy? Before looking at how the law goes about protecting privacy in a somewhat piecemeal way. There's a series of international perspectives, which will probably highlight how weak Australia's privacy protections are. We'll look at the common law of privacy in Australia, the Privacy Act, which deals mainly with our data or information, and then other privacy-related laws, things like trespass, nuisance, breach of confidence, surveillance and listening devices, all indirectly go about protecting and maintaining privacy. And then we'll finish by looking at some of the considerations relating to privacy and the ethical regulators. So let's begin by asking the question, what is privacy? Standard definition is the state of being private. Probably not that helpful, but it goes on. The state of being free from intrusion or disturbance in one's private life or affairs. Secrecy. And being free from intrusion or disturbance really does, I think, highlight how the law treats privacy, with the exception perhaps of information. The idea of privacy surrounding information is a little bit different, as we'll see when we look at the Privacy Act. One thing that is also interesting when we're talking about privacy from the legal perspective is that you don't often see the law specify exactly what is meant by that term privacy. So there is no definition within the Privacy Act, within the International Covenant on Civil or Political Rights or Human Rights declarations. However, there is, within Australian domestic legislation, the idea that interference with privacy occurs when there is a breach of an approved code or national privacy principle in Australia. But generally, we see the law keep what is meant by privacy as being somewhat undefined, and there are probably sound reasons for that. What I would now invite you to do is to go to the discussion board and attempt to define privacy. Okay, against that backdrop, let's have a look at what we can say. Let's begin with the historical background. The idea of privacy has been an important tenet of political philosophy since the age of Socrates and Aristotle, where they talked about both the public and the private realm. Privacy, however, has only become a more recent legal development over the last century or so, as we will discover. But what has remained fundamental, both in those ancient notions of privacy and more recent conceptions of privacy, is the significance of privacy in the home. The home or the household is presumed to be the centre of the appropriately private sphere. So assuming then privacy can be defined, why should we protect it? And much like with defamation, and much like indeed with many other areas of law that we'll be looking at this semester, there is a delicate balancing act between competing values or principles that need to be considered here. So a balancing act must be undertaken between the right of the public to know information and the right of the individual to privacy. It's not as though the right of privacy will automatically trump anything else, and we do indeed see that reflected in our legal system. Now, as I said, legal notions of privacy are a more recent development. They don't sort of go back to the days of Socrates and Aristotle. And if we take the US legal system as an example here, which has influenced the evolution of privacy law throughout the world, it really began going back with an old journal article by Warren and Brandis, which was the right to privacy. And this resulted in the development of 4 distinct privacy torts within the United States. So, we'll come back to those a little bit later on. But as we've sort of seen, it can be very difficult to define what is meant by privacy socially and culturally, technologically and legally. That said, it is generally accepted that the right to privacy deserves special protection. Now, in Australia, the Australian Privacy Foundation has categorised privacy into 4 classes. Now, although this is not enshrined in any law here, it is, I think, a useful way to conceptualise what is meant by privacy. So the Australian Privacy Foundation talks about privacy of the person, privacy of personal behaviour, privacy of personal communication, and privacy of data. So when we're talking about privacy of the person, we're concerned with physical privacy in a person's dignity and personality. That also, in terms of dignity and personality, ties into the privacy of personal behaviour, but there's also property components within that. Privacy of personal communication really is informational privacy, and privacy of data is both informational and property. There is property value in that data. So overall, when we consider it in this context, the right to privacy can be thought of as a bundle of rights, each focusing on a separate aspect of oneself, which is appropriate when you consider what privacy is seeking to protect. So let's have a look at some of those different ideas that are embedded in the classes identified by the Australian Privacy Foundation. So we're going to look at physical privacy, informational privacy, dignity or personality, and then also property. First of all, physical privacy. When we're talking about privacy, in this sense, we're talking about the right to be left alone, to control your own space. That means to be safe from physical harm and other intrusions into your own private life. And it's significant here that we must look beyond four walls and a roof physical definitions. As Chief Justice Gleeson said in ABC and Lena Game Meets, an activity is not private simply because it is not done in public. It does not suffice to make an act private because it occurs on private property. So although the right to control your own space, the right to be left alone builds into that, we shouldn't just be thinking about physical privacy in that sense. The next notion is informational privacy. This is concerned with the right of an individual to access their own information, for that information to be correct, and to restrict the disclosure of that information. Now, this has been the easiest to legislate when it comes to privacy law, informational privacy that is, and we see it mainly protected by the Privacy Act. But it is concerned with both sensitive as well as other types of information. And when we're talking about informational privacy, it's also probably significant to note that there are significant or notable cultural and age-related differences, whereby what someone who is 18 may consider to be private is different from what someone who is 60 may consider to be private, and also between different cultures and traditions in terms of how much you are willing to share of yourself with the world. Another notion that can be useful to think about privacy is that of dignity or personality, and this really goes back to the birth of privacy as a concept in that article written by Warren and Brandis in 1890, and the right to be left alone. Privacy here is the right protecting individual dignity and control over misleading and inaccurate information. Control of information which may be personally embarrassing or very personal. It's difficult, I think, in this context to see that corporations would have some sort of privacy right based in dignity or personality. And then the last sort of way that we can conceptualize or think of privacy is a form of property. And this is about allowing an individual to profit from his or her own efforts, particularly when we're concerned with the appropriation of name and likeness. That said, although we can think about privacy as a property right, what we found as far as the law is concerned is that the courts have stipulated that privacy has its foundation within the protection of human dignity rather than within proprietary rights. Okay, so that now hopefully gives us a bit of a working definition of what is meant by privacy and the different dimensions or aspects to that. Now let's move on and have a look at how a few different countries around the world have treated privacy law. And let's begin with the United States. The United States has quite a body of law relating to privacy. They have constitutional protection for informational privacy in the Fourth Amendment to the United States Constitution. They also have four privacy torts, which are described as public disclosure of private facts, intrusion upon seclusion, appropriation of name or likeness, and publicity placing a person in false light. They also have various statutes that protect informational privacy. New Zealand has adopted and adapted this American tort law. This happened back in a case in 2004 known as Hosking and Runting. In England, they have protection from public disclosure of private facts, which has been used by distorting the action for breach of confidence. And there's a few cases that have dealt with this, and we'll actually look at some of those cases when we consider the law relating to breach of confidence a little bit later on in the semester. The European Union has an established body of law as well. They have the EU Telecommunications Privacy Directive, which updated the European Union Privacy Directive. This directive required all European Union member states to enact comprehensive privacy legislation, requiring organisations to implement personal data policies to include transparency, purpose limitation, data quality, data transfers, special protection for sensitive data, government authority, data controllers and individual redress. And Article 1 of the directive requires member states to protect the fundamental rights and freedoms of natural persons, and in particular their right to privacy with respect to the processing of personal data. In essence, the European Union has therefore made privacy a fundamental human right. There are also a range of other international instruments. So, for example, Article 12 of the Universal Declaration of Human Rights provides that no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honour and reputation. Everyone has the right to protection of the law against such interference or attacks. There's also some OECD guidelines, so the OECD Guidelines on the Protection of Privacy and Transport of Personal Flows of Data, and the OECD Guidelines for the Security of Information Systems and Networks. And in the Commonwealth law, we have the Commonwealth Model Privacy Act. So that gives you just a quick little snapshot of how some of the countries around the world deal with privacy. What we are now going to do is to have a look at how Australian courts, as well as the Australian parliaments, have dealt with privacy. And we'll begin by looking at the common law of privacy before moving on to the more established regime that we see with respect to legislation and the Privacy Act. So, the common law. Now, just a reminder here, when we're talking about the common law, we're talking about law made by the courts, that is, judge-made law. Now, initially and historically, at least in Australia, the protection of privacy was limited to informational privacy, basically your data, as we see under the Privacy Act, and under a range of other related causes of action such as trespass, nuisance, defamation, and some aspects of the criminal law. However, we have seen some decisions in recent years that have developed a common law notion of privacy in Australia. And this goes back to ABC and Lena Game Meats, a decision of the High Court, and a decision of the Queensland District Court in Gross and Purvis. Now, these decisions indicate that the court may be willing to reconsider an old case from all the way back in 1937, known as Victoria Park Racing and Taylor, where the High Court had held that there was no right of a tort of invasion of privacy. But as I said, we've moved away from that, so let's have a look at what these cases have said. So the first, ABC and Lena Game Meats. In November 2001, Lena Game Meats, a company that processes possum meat for export, asked the High Court to restrain the ABC 730 report from broadcasting footage of its operations in Tasmania. The footage, namely the footage of the possum slaughtering operations, was made by hidden cameras in the walls and ceilings of Lena Game Meats' factory. Importantly, the film was made by a person unknown, who then supplied it to an animal liberation group, which in turn passed it on to the ABC. Now, Lena Game Meats argued that the publication of the film would cause it financial harm. It argued that the footage depicted some of the most gruesome parts of the processing operation, and that it was likely to arouse public distress and anger. It did not claim any intellectual property rights in the film, nor did it argue that the film was defamatory. Rather, it made three allegations. That first of all, the slaughtering operations were Lena Game Meats' confidential information, and publication of the film would breach its confidentiality. That secondly, publication of the film should be restrained because the film was made surreptitiously and illegally. And that thirdly, the publication of the film amounted to an invasion of Lena Game Meats' privacy. Now, ultimately, this action was unsuccessful, but it did nonetheless make a few interesting conclusions and observations. So let's consider each of those three arguments in turn: confidentiality, unconscionability, and then privacy. With respect to confidentiality, The court held that the activities of Lena Game Meats could not be regarded as relevantly confidential, even though the premises upon which the information was obtained was private property. The fact that the operations were required to be licensed by a public authority suggested as well that the information about the nature of those operations was not confidential. So that argument was unsuccessful. In terms of the second argument relating to unconscionability, the court said that the mere fact that the footage was obtained improperly in the first place did not taint the use and publication of the film for every other person into whose hands the film may fall. They said it would be quite remarkable to hold that speech by a law-abiding possessor of information can be suppressed in order to deter conduct by a non-law-abiding third party. And then with respect to privacy, although the court held that there was no right to privacy in this particular case, the court indicated that in the future it would be receptive to arguments about some sort of privacy right being recognised in Australia. The court referred favourably to the privacy torts that had been in place in the United States and had been set up under what's sort of described as the restatement of the law second of torts. As such, the High Court may consider a tort available where a person intrudes upon the personal affairs of another, where the matter made public is highly offensive to a reasonable person, and there is insufficient public interest in having the information disclosed. Now, Lena Game Meats had also argued that such a cause of action was available or should be available to both individuals and corporations under Australian law. 4 of the 6 judges, though, on that case were inclined to the view that if a new cause of action for the invasion of privacy was to be developed under Australian law, it should be limited to protection of the privacy of a natural person, as opposed to a company or similar body, and so it couldn't obviously extend to Lena Game Meats. So, although there was not much relief for Lena Game Meats in that particular case, the fact that the High Court seemed to indicate that Australian law could accommodate a privacy tort left the door open for it to be argued in subsequent cases. And indeed, it came up in the case of Gross and Purvis, which was a decision of the Queensland District Court. So what was going on in that case? In Gross and Purvis, the 53-year-old plaintiff was harassed over a continual period of time by the defendant. Such harassment included repeated telephone calls, threatening letters, loitering near the residence and business of the plaintiff, breaking into the plaintiff's home, and following the plaintiff during her day-to-day activities. Now, this occurred over a period of 8 years. The plaintiff was ultimately awarded $178,000 plus interest and costs for compensatory, aggravated compensatory, and exemplary damages. The judge of the District Court, Judge Skane, found that there was no longer a barrier to a tort of invasion of privacy because of the High Court's reasoning in the Lena Game Meats case, and His Honour suggested that there would be 4 elements of this tort. First, a willed act by the defendant. Second, this act must intrude upon the privacy or seclusion of the plaintiff. Thirdly, in a manner which would be considered highly offensive to a reasonable person of ordinary sensibilities. And fourthly, which causes the plaintiff detriment in the form of mental, physiological, or emotional harm or distress, or which prevents or hinders the plaintiff from doing an act which he or she is lawfully entitled to do so. This has been followed by the Victorian County Court in the case of a disclosure of private information where there was a reasonable expectation of privacy. So, what do these decisions conclude about privacy? Well, Lena Game Meats tells us that Victoria Park does not stand in the way of the creation of a tort for the invasion of privacy. However, that right will be an individual one and not one that is afforded to businesses or corporations. And as far as Gross and Purvis is concerned, it's the rare creation of a tort for invasion of privacy with elements espoused. The question you'll need to consider, though, is given what we learned earlier on in the semester in relation to court hierarchy and jurisdiction, how binding is this decision of the Queensland District Court actually going to be? So, that's the somewhat uncertain state of the common law in Australia. Now, let's take a moment to look at privacy legislation. Now, up until 2001, the Privacy Act was quite limited. It was based around a set of 11 information privacy principles, and it only applied to Commonwealth government agencies, the handling of tax file numbers by all organisations, and the use of credit reporting information in the private sector. However, we saw some reform that had been prompted by some pressure from the Victorian government, the European Union's Privacy Directive, and consumer research indicating that privacy protection was an important issue. And so we now have more comprehensive privacy legislation. The Commonwealth privacy legislation now binds government agencies as well as business organisations. That is, businesses and individuals as traders who have an annual turnover of $3 million. Now, most of the other states and territories have their own form of privacy protection, but the Commonwealth Privacy Act is the overarching legislation. And what the Commonwealth Privacy Act is concerned with is personal information, and it aims to protect the personal information of individuals. So, what is meant by personal information? Personal information is defined as meaning information or an opinion, including information or an opinion forming part of a database, whether true or not, and whether recorded in a material form or not, about an individual whose identity is apparent or can reasonably be ascertained from the information or opinion. Now, as you can probably tell from reading that, that is a very broad definition. So, how does the Privacy Act aim to protect personal information? Now, it utilises the national privacy principles as well as the information privacy principles. The national privacy principles relate to organisations. The information privacy principles relate to government agencies. Now, the most relevant information privacy principles and national privacy principles for media organisations include IPP NPP1, which is concerning the manner of collection of personal information, IPP2 and NPP1, the purpose of collecting personal information, IPP4 and NPP4, the storage and security of personal information, IPP10 and NPP2, preventing the use of personal information other than for the purpose for which it was collected, and IPP11 and NPP2, protecting the disclosure of personal information to any other person, body, or agency. Now, both IPPs 10 and 11 and NPP2 are subject to the following exceptions. Consent by the individual, the use or disclosure where it's believed necessary to prevent or lessen the seriousness and imminent threat to life or health of the individual or another person, where use or disclosure is required or authorised by or under law, where use or disclosure is reasonably necessary for the enforcement of criminal law, imposition of pecuniary penalty or protection of the public revenue, and where the use is directly related to the purpose for which the information was obtained, the individual is reasonably likely to be aware or was made aware that that information of that nature is usually disclosed to that other person, body, or agency. Now, the media enjoy an exemption from the national privacy principles for information collected for journalistic purposes, so that's worth noting. Now, there's a few different problems with this Privacy Act. It's fragmented and quite difficult to follow. There's a range of exceptions that apply to many different organisations. The Privacy Commissioner does not have any real power to order compensation or to investigate or to issue fines for breaches, and it becomes increasingly difficult to deal with emerging new technologies, especially the internet. But we continue to see pressure for reform in this particular space. Now, in addition to the Privacy Act and some limited common law claims for a tort of invasion of privacy in the lower courts of Queensland, there are other forms of protection of privacy which are available within the common law. Now, these are generally common law actions which aim to protect other, that is, non-information forms of privacy-protected ideals, such as privacy in property and privacy in personal communications and dealings. So we're going to have a look at just briefly at a few of these related areas. The first is trespass. The tort of trespass recognises that a person in possession of property has a right to refuse entry to their property. Now, journalists may have a problem with trespass when attempting to enter a property to interview an individual. The elements of trespass are as follows. First, that you enter a property without consent, that you remain on a property where consent has been given but withdrawn, and where you place a listening object or camera on a person's property without their consent. That said, filming or photographing without entering land or premises, however, does not amount to a trespass. The next one is nuisance. The tort of nuisance can be invoked where there is substantial and unreasonable interference with the rights of the occupier of a property to enjoy the peaceful possession of that property. This, unlike trespass, can take place outside the bounds of the property. So, for example, unwarranted and persistent telephone calling, surveillance, etc., could all give rise to a cause of action for nuisance. The next one is breach of confidence, and we will consider this in more detail in a future week. But for the moment, the tort of breach of confidence is underpinned by the principle that someone who has come into information in confidence should not take unfair advantage of it. A duty of confidence can arise from a contractual basis or based on the context of the relationship it is conveyed in. Now, much of the focus when we're talking about breach of confidence is on the quality of the confidential information. If the information is highly sensitive, it is likely that a duty of confidence will be inferred. And information ceases to be confidential when it has been made public. Now, a case that illustrates this is Giller and Prosopets. In this case, Mr. Prosopets videoed himself and his former de facto partner, Ms. Giller, having sex, at first secretly, but later with her consent. When their sexual relationship ended, Mr. Prosopets showed the videotapes to Ms. Giller's family, friend, and employer. Ms. Giller sought damages alleging breach of privacy and/or breach of confidence and/or intentional infliction of mental harm. The court held there was no reason that Ms. Giller should not be able to recover damages for the distress caused by this type of breach of confidence and awarded her some $40,000 in damages. As the High Court did in Lynn and Gamemeat, the Victorian Court of Appeal in this case sidestepped the question of whether Australian law should recognise a tort of privacy, stating that it was unnecessary for it to decide this issue in light of its findings in relation to the action for breach of confidence. So breach of confidence can be used to indirectly provide a legal basis for protection of privacy. And then the next one is surveillance and listening devices. There's a few different relevant provisions here that are particularly pertinent for journalists and media organisations. So the interception of a communication passing over a telecommunications system is prohibited. It is also unlawful to authorise, suffer, or commit another person to intercept or to do any act or thing that will enable the person to intercept a communication. And this is provided for in the Telecommunications Interception Act. The prohibition against unlawful interceptions is supported by prohibition against the communication to another person making use of or making a record of any information obtained by the interception. Now there's also some Queensland law. The listening to or recording of a private conversation to which the person is not a party is prohibited, and this is in Section 43 of the Invasion of Privacy Act of Queensland. Private conversation is defined variously as a conversation or word spoken by one person to another person or persons in circumstances that may reasonably be taken to indicate that any party to the conversation desires it to be listened to only by the parties to the conversation themselves and by some other person who has the express or implied consent of all the parties to the conversation to do so. There are some exceptions to this offence relating to the use of a listening device pursuant to a warrant or authority and the unintentional hearing of a private conversation by means of a listening device. The prohibition against the use of listening devices is supported by a prohibition against persons communicating or publishing the conversation of any information or material derived from the unlawful use of a listening device. Now, it's worth noting, though, that Queensland does not prohibit the recording of a conversation by a party to the conversation, but it does prohibit communication or publication of the substance or meaning or report of the conversation to a third party. In Queensland, the exceptions to the prohibition of communication or publication to a third party are those to another party to the conversation, with the express or implied consent of all the parties to the conversation, where it was made in the course of legal proceedings, or where it is no more than is reasonably necessary in the public interest, or in the performance of a duty of the person making the communication or publication, or for the protection of the lawful interest of that person, or made to a person reasonably believed to have an interest in the private conversation so as to make the communication or publication reasonable under the circumstances. So that's then the state of the law in Queensland. A final thought. Invasions of privacy may be the subject of a complaint to the Press Council. An invasion of privacy might also be a breach of the Code of Practice and the Federation of Australian Commercial Television Stations or the Federation of Australian Radio Broadcasters. Journalists should also respect the private grief and personal privacy of an individual. This comes from the MEAA Journalists Code of Ethics. So even where the law might not be violated, you need to remember your ethical responsibilities. This then brings us to an end of this podcast in week 5 dealing with privacy law. Thank you.